Hello, and today we're having a look at psychiatric harm that occurs as a result of negligence and how the courts deal with this issue. So in my first video, we had a look at these primary victims, i.e. they're people who fall directly into the zone of danger that you can reasonably foresee will suffer some harm as a result of the defendant's negligence. Now, secondary victims are different. They're people who suffer mental trauma as a result of somebody else's injury or as a result of fear that such injury might come to them. And it's pretty wide because we all are witnesses to so many different injuries, or we might be so fearful of different injuries that might occur to us. Therefore, secondary victims are treated much differently to primary victims, and we restrict it. So what is the test for secondary victims? Well, basically in McLaren, I don't know how to pronounce this case name, but I'm just going to say McLaren. You can read it afterwards, I'll write in the bottom. McLaren and OBrien, 1983. Lord Wilberforce, he said there's three key limitations that have to be placed where you're looking at secondary victims. That is the class of people who should be recognised, the proximity that such people have to the accident, and the means by which the shock was caused. Now, this was embraced, even though in McLaren, we can talk about this case later, but basically Lord Wilberforce, he was happy to give the lady a claim in psychiatric harm because he wanted to allow an incremental development of the law in this area, whereas the other judges, they took a different approach, and they basically, I think they were arguing there's a presumption that liability should arise whoever the claimant's suffering with psychiatric injury, were they reasonably foreseeable. There's like a presumption, and then you have to mitigate that on an ad hoc basis with policy, as opposed to Lord Wilberforce, who he was talking about an incremental approach. Now, there was this divergence in the case, but then what happened is in Alcock and Chief Constable of South Yorkshire 1992, Lord Wilberforce's approach was endorsed and a twofold test for secondary victims was established. And what did this twofold test consist of? Well, the first one is that it was a psychological illness or harm itself that must be reasonably foreseeable. So unlike in the cases of primary victims, it's really not sufficient to say any kind of personal harm. You need it to be psychiatric harm particularly. So the key issue with the first round of the test is this idea of extra sensitivity. So we can use now two cases to talk about this. When we look at the case of Borehill and Young, this is where basically the pregnant woman, she sees this accident and the motorcyclist in a bad state following this accident, and she has a miscarriage. Now, she was extra sensitive because she was pregnant, so they couldn't take that into account, that because what test you're taking into account is was it reasonably foreseeable to a person, to an ordinary person of fortitude, not somebody who has these extra sensitivities like being pregnant. However, we must understand that where you can produce evidence and show that you're a secondary victim, if you have some kind of abnormal susceptibility, then you can claim for those further injuries that were sustained, and this was established in Bryce and Brown 1984. So it's a very subtle difference here. So if you can anyway establish your secondary victim, then yes, you can claim for extra sensitivity. However, if you can't show that, then you can't be showing your extra sensitivity as a reason in order to claim damages. So that's the key issue with the first round of the test when you're looking at whether psychological illness was reasonably foreseeable. The second part of the test is divided into 4 sections, and basically what it is that the courts have to look at control mechanisms, and only if you meet those control mechanisms can you establish yourself as a secondary victim and thereby claim damages. So what are these 4 requirements you need? You need a proximate relationship, you need proximity to the accident, you need to have perceived the event in a particular way, and sorry, I forgot where I wrote number 4. The manner in which the psychiatric illness was caused has to meet the standards that the court prescribes. So let's begin with the nature of the relationship between the claimant and the primary victim. So, i.e. the proximity of the relationship. What the law requires is a close relationship of love and affection. How do you go about showing you had this close relationship of love and affection? Well, the first thing is there's a presumption that certain relationships have this close tie of love and affection, such as that of a parent and a child. However, if you are relying on evidence, then you need to prove that you had this, and it will require, evidence that you've had a loving relationship. And this can easily be shown and has been, for example, in the case of McCarthy and Chief Constable of South Yorkshire 1998, where it was proven that a proximate relationship existed between two stepbrothers. Now, this is even more important because when we were looking at the presumption that certain relationships equal the proximate relationships, such as that of a parent and a child, sibling relationships are not considered because sibling relationships vary so much. Some siblings get on, some don't, and they're so different that it's not considered. But here, stepbrother relationship was said to be proximate because of the evidence they brought. What about if you're a mere bystander? Well, in theory, you should be able to claim for damages because, as Lord Ackner makes clear in Alcock, he gave an example of a passerby who witnesses a patrol tanker getting out of control into a school in session and bursting into flames, and he said that he wouldn't exclude the possibility that a proximate relationship existed between the bystander and the primary victims in this case. So technically it can, but this is actually never translated into reality. And as we saw with Borhill and Young, the proximate relationship test failed there. And also in the case of McFarlane and EE Caledonia Limited 1994, it was similar facts to Lord Ackner's example, so they relied on it. But, the Court of Appeal, they declined that it had met the requirement of a proximate relationship, citing, different objections that, for example, there's no scale at which to compare whether this horror was enough in order to accept that a proximate relationship existed. And the final issue with proximity relationship is, do you need to just have a proximate relationship to the primary victim? What if you had a proximate relationship to a property? So in Atian, British Gas 1988, the lady's house went on fire and she was able to say that she had a proximate relationship with her house. So in theory, certain property you could claim to have a proximate enough relationship to claim damages to any trauma that's caused by them. So then the second requirement is that you must be proximate to the accident, i.e. you must have been a witness to the accident or been present in the immediate aftermath of an accident. And this is made clear in the case of W and Essex County Council 2000. So here basically we just need to look at a bunch of cases to explain what we mean by proximity. So in McLaren, a wife made a claim for mental harm on the basis of immediate aftermath because when she went to visit her family members, they were found in the same condition as they had been in the accident. They had oil and mud on them, they were distraught with pain, and so therefore that counted as immediate aftermath. There is a suggestion though that had her family members been cleaned up, calmed down, consoled, then that wouldn't count as immediate aftermath. In Alcock and Chief Constable of South Yorkshire 1992, the court refused to extend the meaning of aftermath to include the identifications of the victim's body because it happened 8 or 9 hours later, and the whole point, the purpose was to identify the body that they were coming to see the primary victim. Whereas this can be compared to the case of galli-atkinson and Senegal 2003, where when they went to see their daughter's body in the mortuary, basically it was different because the parents, the mother had gone to accept that the child is dead because she had already somehow ended up at the scene of the accident when the police were there. So it wasn't to identify, it was to accept that she had lost a child. That was counted as immediate aftermath. And actually, the courts are quite flexible because the Court of Appeal, for example, they pushed the idea of immediate aftermath in the doctrine of Walters and North Glamorgan NHS 2003, where they found that a 36-hour period beginning when the infant's son had suffered epileptic fit and ending in his death could be counted as immediate aftermath, because they described the whole thing of the son dying in the mother's arm from start to finish as a single horrifying event where you witness the person's harm, and you've got mental disorder of seeing this kind of harm. And the key thing here is the mother that didn't cause the child to die, was to do with some negligent treatment. So, but you can see the point I'm getting across here is that courts are quite willing to be quite lax about certain things. The third requirement is that you must have perceived the accident, the primary victim, through sight or hearing, and it has to be sight of hearing of the actual event or of the immediate aftermath. So that's how they require. And so in Alcock, the House of Lords concluded that those claimants who had only viewed the disaster on TV or listened to the radio, they were barred from recovering for that reason, is because when they witnessed it, although there was sight and hearing, and you could argue it was immediate aftermath or timing, what they hadn't witnessed it in a way that they could identify the person, the primary victim they knew suffering with this problem. They just saw a crowd suffering this problem, so it wasn't specific. So you have to perceive the event in a way which is specific to your exposure to the primary victim. And the last key control mechanism is that the psychiatric illness, it has to be caused by a specific shocking event. It can't be like going on for a long time. So the mental injury has to be occasioned and come about specifically from a shock, not a series of events, which is exactly what happened in Sion and Hampstead 1994. The Court of Appeal struck out this guy's claim partly on the basis that the illness was not regarded from a shock but a process and some time of him being in hospital and witnessing this kind of harm. So in my next video we'll have a look at the policy reasons for the restriction of recovery on pure psychiatric harm. Thank you for watching.